Now that everyone is here, we're going to go ahead and get started. Thank you all for joining us.
Hello, nice to meet you.
You are at Regulation on the Horizon, what you wish your lawyer had told you about. So remember, you all volunteered to come here, so now you know, right? So you can't pretend you don't know afterwards. If you have any questions, we'll be taking questions about 10 minutes prior to the end of our 50 minutes together. Please line up in front of the stand-up mics that you see, and we'll take as many questions as possible. And then after the session, just so everybody can do their proper work that they do to clean up and get organized for whatever's next in here, please let the speakers come off the stage safely, and then they can continue to talk to you as they exit the room, usually out the front, so that we don't crowd everybody up here. Thank you again for joining us.
Thank you, and thanks everyone for joining us today. I'm incredibly excited to be hosting this panel. I'm Beth George. I work at Freshfields, Bruckhaus, Deringer, which is a law firm that specializes in a number of issues, including global data issues for our clients. And I'm joined on the stage today by JJ Jones from Microsoft, Levy from Autodesk, and Stacey Schesser from the Department of Justice in California. It's an all-star panel, and we want to talk about regulation on the horizon. And I'll start by saying we only have 50 minutes, and we've had to make some hard choices about what to talk about and what not to talk about. I don't think at any point in my 2 decades of working on sort of cybersecurity and regulation have I seen as many regulations being proposed and coming out and changing sort of how we need to focus our energy and time as I have in the last year to 2 years. And I think part of that is the current administration, which has a flood of officials, I think perhaps the most that we've seen at RSA, at least in the last few years. But everything from CISO liability and multiple agencies thinking about how to hold CISOs accountable to considerations on disclosures to making CISOs part of the securities disclosures for public companies. We're just seeing a massive amount of change and what I would call positive law in this area. So there's a lot to cover. I'm going to try to keep us on time, and so I'm going to push through a number of topics. But I wanted to start with personal civil liability because I know it is a source of great pain. I also know that Joe Sullivan is here at RSA and talking about his case, so we're not going to focus on his case in particular, but there's 2 other cases that I really wanted to dive into. And the first is what the FTC did with Drizzly. So the FTC's case against Drizzly, the CEO of Drizzly, did not focus on a CISO, but it was about personal liability for security. And what was really interesting about this case is that the FTC held the CEO accountable not merely for the conduct at Drizzly, but also going forward, that any other company he became the CEO of or became an executive of, he would still have the same agreements bound to him in that oversight going forward. So while his case is in the past, the sort of impact for him is in the future, and I think it's a novel way that the FTC is thinking about holding people accountable. So Katya, I wanted to start with you. Can you sort of walk us through the facts of Drizzly?
Sure. Thanks, Beth, and thanks everyone for attending the session today. So the Drizzly case, as probably many of you know, in 2023, January, the FTC issued a consent decree and finalized a consent order, which basically resulted from a data breach that happened in 2020. And the facts of that case are in 2018, an executive was granted access to the GitHub repository of the company for purposes of attending a hackathon. And after hackathon ended, access was not revoked. As a result, threat actor was able, 2 years later in 2020, was able to gain access to the GitHub repository of Drizzly. It was determined that the company did not require strong authentication, passwords. There was no MFA required, which made it easier for the threat actor to gain access. Once he was in the repository, the GitHub repository, they were able to gain access to the source code and find out vulnerabilities, which further led them to gain access to the production environment of the company in AWS, where they held customer data. As a result, the threat actor was able to exfiltrate sensitive personal data of 2.5 million consumers, which resulted in the consent decree and the claims the FTC brought against Drizzly and against the CEO, as Beth mentioned. The FTC charged both the CEO and the company with violation of Section 5 of the FTC Act, and it held that the acts not having appropriate security constitutes unfair practice under the FTC Act, and also found that the company had deceptive practices when they published in their privacy statements that the security they had was strong and reasonable. So on those two grounds, the FTC found, made the claims and issued the consent decree. And as Beth mentioned, the consent decree obligates, like many other FTC cases prior to that, the company to remediate the failures of security that they were found and implement strong and robust security measures going forward. But what was also unique and interesting about that case is that with regards to the CEO, personal liability was found as well, and the CEO was ordered for 10 years going forward, regardless of whether he stayed at that company or went to other companies in the future. He also, to the extent that he was in a CEO position or senior management with security responsibilities, he is required to implement cybersecurity program in any company that he works in the future if the company handles personal data of more than 25,000 individuals. So the takeaways from that case are quite significant. It signals that the FTC views requirements that companies protect consumer data very seriously. They're not going to tolerate deficient security controls, and they're going to intend to continue to exercise their broad powers under Section 5. So the takeaway here is to take this seriously, and it's just raises concerns about potential liability, not only on the company level, but also personal liability of executives, whether it's the CISO or the CSO.
Yep. And it's not the first time that we've seen the FTC in recent years sort of hold individuals personally liable. Most of you are probably familiar with the Cambridge Analytica case and Facebook. In that one, Mark Zuckerberg himself was also held personally liable. And so you're sort of seeing a trend here in the regulators. Obviously, we can't talk about personal liability without talking about the SolarWinds case. I'm assuming that most of the people in the audience are very familiar with the case. It ruined many of our Christmases about 2 years ago. And it was not much of a secret that the SEC was conducting investigations into how the SolarWinds impact. I think at the SEC, for most companies that were a client or customer of SolarWinds, they received a notice from the SEC asking them about, were you impacted? How did you assess your materiality? Did you do a disclosure, and so forth? But what did come as a little bit of a surprise to many of us is earlier this year, the SEC charged the CISO with fraud in addition to the company, largely around failures to disclose material weaknesses in their cybersecurity, as well as the CISO had put out a number of blogs sort of promoting SolarWinds security, which they found to be not true, and he was in fact charged with fraud. In full disclosure, my firm has filed a amicus brief in his case opposing his personal prosecution. But we're not the only, group and organizations sort of concerned about this turn of events. JJ, I know a number of companies have sort of also filed amicus briefs around this issue. Can you sort of talk about the impact that it's having in-house for CISOs, for security professionals as they're thinking about, cybersecurity weaknesses, cybersecurity debt, and sort of the SEC rules and public disclosures.
Yeah, happy to, and happy to be here, and thanks so much everyone for joining our panel today. Am I on? Yeah, okay. So thanks so much for joining, happy to be here, and just want to say that my comments reflect my personal opinion after almost a couple of decades of practice representing companies, being at a couple of very large organizations dealing with cybersecurity and trying to help them navigate that. I think, particularly the SEC v. SolarWinds case has caused a lot of consternation among CISOs or others in that, sort of lead security role, regardless of what that title is at your organization. I most probably can think of some internal statements or documentation or emails where they have raised concerns about their organization's cybersecurity posture or hygiene or noted different weaknesses. That is the CISO's job. And at the same time, CISOs or chief security officers, they have a role to speak to a variety of different audiences about their organization's cybersecurity posture and hygiene. And so, being in that place of talking to your internal auditor, talking to government in many different roles, right? You could be talking to the government in its role as investigator or customer, et cetera, and your other customers, your commercial customers, your business partners, your board, your management. It puts, I think, CISOs, particularly in the wake of this SEC case, this enforcement action, it'll be, it's uncertain right now where it will land, right? And, will SolarWinds and Tim Brown, will their interests continue to align and sort of, will they stay on the same side of this case in the long haul? But I think it's just caused a great deal of consternation internally in terms of navigating those different conversations with sometimes, different standards in terms of, what the chief security officer is required to say, the depth, the breadth, right, of their responses in different contexts. All together, though, I think it says, you want to try to ensure that your internal communications are consistent with what you're saying to these different audiences. And I think that's the gist of it.
Okay. Thanks, JJ. And Stacey, I know you can't comment on this case specifically, but states attorneys general are getting very involved in cybersecurity, and I'm wondering what the message has been or the thinking is around sort of CISOs who are trapped between, I think, the reality of massive cybersecurity debt and sort of regulator expectation of increased transparency around cybersecurity.
Thanks so much. Oh, hello? Maria? Hello? I was late, so I couldn't get mic'd, but you all saw me do a mad dash and sprint through the Moscone Center, so. People say that sometimes state investigations take a long time, but I would argue that I got here pretty quick. I don't think this is working. Should I just, Jersey? I'm from Jersey originally, so I can speak loud.
Hello?
Check.
Thank you so much. Okay, so whoa, that's loud. My views are my own. So we're talking about data security. I would argue that state attorneys general have been on the cybersecurity beat for a very long time. As you know, California was the first state that had a data breach notification statute in place requiring notice when there's been a data breach for classic data points involving consumer data. And now every single state plus US territories have a data breach notification statute in place. There's only one very large entity that can't seem to pass that type of law, which is the Congress. But California has been very active in pursuing cybersecurity cases. including, for example, one of the biggest cases I worked on in the multi-state context along with federal partners was with Equifax, as well as in the case of Uber, and I realize that Joe Sullivan is speaking here, but that case arose because there was lying in the context to regulators. And so, my boss, the head of the consumer protection section, says that he works on cases having to do with lying, cheating, and stealing, and so do I in the context of privacy and data security. Oftentimes, when companies make representations about data security practices, everybody says, we take privacy seriously. They also say that we follow data security standards. And so when a company is under investigation and we realize that they do not, in fact, follow basic security standards, that is a problem, and that is usually one in which we might make a determination that the law has been violated, leading to an enforcement action. So while I understand that CISOs or CISOs have to be good advocates and be good stalwarts for representing what their security practices are, you also have to take a giant step back and make sure that those practices align with what you're telling consumers especially, or face risk of potential enforcement. I think that for years the FTC has been saying start with security. They put out tons of literature, so it's really not a surprise to see that this is an area for consumer protection enforcement, and an area that has really captured the eye of state regulators as well. And I think it will continue to. We are seeing now cases in which companies are victims themselves of ransomware attacks, and those are quite serious. But when you pull back the curtain and you take a good look, you also have to make sure that their security standards are up to par with what the industry standards are. And so if they're not, that's a problem. So if consumers are trusting you with their data, and you're making representations, whether they're public statements, whether they're statements in filings, whether they're in privacy policies or other type of consumer-facing statements, you need to make sure that those align with what your actual practices are.
Okay, so I want to stick with the SEC for just a minute, because I think one of the biggest sources of heartburn right now are the new SEC cybersecurity rules. They sort of designed to do two things. One, they're trying to force companies to mature their cybersecurity practices in what I think the SEC views as sort of been like an absence of market pressure to do so. And two is trying to force boards to get real skin in the game when it comes to cybersecurity. But sort of the devil's been in the details. I think that since the SEC rules have been passed, we've seen less than 20 public filings of 8Ks regarding cybersecurity incidents. And of those, I think the vast majority have said these aren't material incidents, which has been sort of surprising for us to see that the 8Ks were filed anyway. But let's sort of dig down onto the details of this particular rule and talk a little bit about the incident reporting requirements in the SEC rules. JJ, can you sort of walk us through sort of the rules requirements?
Yeah, and I think, first it's helpful, at least the cybersecurity practitioners or lawyers that support cybersecurity practitioners to, think about the SEC and it's different authority, it's different purpose, right, which is all around protecting investors. It's not about making us more secure and more safe in terms of cybersecurity. And so, why would they decide to come out with new rules that essentially required companies or organizations to do things that they were already required to do, which is, file a form, a SEC filing, if they have a material incident, regardless, right, of the nature of the incident. What that says to me is that the SEC felt that CISOs were very concerned and organizations were very concerned about cybersecurity risk and incidents and the impacts to their organization of a cyber attack or a big data breach, but they were not seeing a consummate level of disclosure in their SEC filings, and they felt there was a lack, right, a lack of information flowing to investors such that they could make investment decisions based on that information. So they came out with the rule that became effective in December 2023 that says, if a company determines that they have had a material cybersecurity incident, they have to file a Form 8K, if they're a domestic issuer, a Form 8K on that incident within 4 days of making that determination. When do they have to make that determination? The rule says without unreasonable delay. What does that mean? I think we'll find out when we start to see the SEC picking apart some of the 8Ks that have been filed, and of course companies that haven't filed these filings publicly. What do you want to have in that disclosure? Well, your disclosure needs to speak to the nature and the timing and the scope of the incident. So essentially, what happened? When did it happen? Is it still ongoing? And also it has to speak to the material impacts or the reasonably likely material impacts of this incident. That can go to operational impacts, reputational impacts, your customer relationships, changes to your business strategy, of course, financial. But it's been noted by the SEC that it's not a purely quantitative consideration, right? It's a mix of factors, a total mix of factors, and so you could have an incident that has a small dollar impact, at least when it's being assessed for materiality, but a big qualitative impact, for example, reputational risk to your organization. In terms of other guardrails there, guidelines there, it's the kind of thing that a reasonable investor would consider important, essentially, to making a decision about purchasing or selling that stock. And then also, I wanted to make sure I mentioned, you can get a 30-day delay in filing your Form 8K if you get the U.S. Attorney General to essentially state that filing the disclosure about the incident will have an impact or risk national security or public safety. Of course, right, there's impact to an organization if you were to say that, have that come out about your incident, but there is opportunity if a company were to think that was a real potential impact to have that delay. Again, it's just a delay. You still would have to ultimately file it.
And I was on a panel just last week with Sean Newell from the National Security Division of the Department of Justice, and he said that he could publicly disclose at that point no companies had sought the delay, much to my chagrin as someone who had fought very hard to have that in the rule. Katya, there's sort of two major pieces of the rule. There's the disclosure, and then there's governance requirements. Can you talk to us a little bit around the governance requirements?
Sure, and I also should have added that the views are my own that I'm expressing on this panel. So the SEC rules around governance and the new rules are not only when an incident occurs in the 8K form, as JJ described, but also in general, companies are required under the new rules once a year when they're filing their 10K form, which is financial disclosure of how the company is doing financially. Companies have to talk about two things when it comes to governance. The first one is cyber risk management. And what this means is companies have to explain what are their processes, what are their policies of handling, identifying, and managing cybersecurity risk, what are the pillars of their security programs, how do they, what training is provided to employees internally, how does the company monitor compliance with its security controls, is the company working with third-party assessors, consultants, auditors in order to keep its processes updated and mitigate any vulnerabilities. So that's the first aspect of the governance that needs to be disclosed in the 10K yearly filing. The other requirement is around governance. So the companies, publicly traded companies, have to disclose the role of the board of directors and also the senior executive management in managing cybersecurity risks. So here, companies have to explain what is the role of the board of directors. Are they in the management of cybersecurity risks? Are they regularly informed about risks, and do they make any decisions? And same for the executive management. What is the day-to-day job of the CEOs and executive suite? What is their, how are they tasked with overseeing and management of cybersecurity risk? It is also, it can be appropriate in this disclosure to also talk about specific expertise that either the board of directors or executive management have in cybersecurity. That will be appropriate to speak to that in the disclosures as well. So that's, in a nutshell, the requirements around cybersecurity governance that companies have to describe.
And so I think what we've seen, I mean, the SEC has cared about cybersecurity for probably 14, 15 years. I mean, they've got guidance going back to 2011. But sort of where they are now, so they've put out a rule. Originally they had proposed that at least one board member was a cybersecurity expert, and now they've sort of gone the route of sort of name and shame, so that you have to disclose the experience of your board on cybersecurity. But like really focusing on governance, really focusing on requiring incident response, probably the most, one of the most difficult to meet around disclosure of some incidents, at least broadest. And they have the prosecution of SolarWinds CISO. So they've really, I think, sort of advanced themselves just at the forefront of cybersecurity. Stacey, I'm wondering how much your AG's office is paying attention to what's happening in the SEC, and to what extent you're sort of looking at those regulations and maybe thinking about piggybacking off of them.
Sure. So I would say that, we are looking at everything, right? We look at what the FTC does, we look at what the SEC is doing, we look at what other states are doing. We are used to working in partnership. We work in partnership both within the state of California, we work across state lines, we work with federal partners, we even consult internationally as well. And that's something that's typical within the privacy and the security worlds. And so I would say that, looking at these new rules, it's interesting to see where the SEC is going and what they're thinking about, and how they're starting to think about this from a governance standpoint that was mentioned as well. But also, seeing that this is an additional disclosure requirement for a company, and it's broader than, for example, state law, right? California state law has a reasonable security requirement as it relates to personal information, which are classic data points, but this seems much broader in terms of what would constitute a material cybersecurity event, for example. And so, when we evaluate companies, we look at all types of public statements and public filings, 10Ks, 8Ks, to get a whole sense of what is going on with a company that might potentially be under investigation. I think that it's always important to learn and see how other public sector entities are viewing certain changes as well. I think that this is a very interesting development. We pay pretty close attention to these types of announcements. I would just say that. I would also note that, for enforcement purposes, I don't see necessarily how this could be, but I envision that there's always a possibility. But under California state consumer protection statute, the unfair competition law, we can prosecute any violation of federal or state law as a violation of California's unfair competition law. And so if there's some sort of violation of this rules, regulations, statutes, anything, that could actually be a predicate for a potential unlawful unfair competition action. So, that is why it's really incumbent on us to pay close attention to, different types of rules that come out of with our federal partners. And we engage in very robust conversations to learn from them, and I think it's a critical part of keeping yourself informed, but also keeping a broad enforcement lens.
Stacey, I want to stay with you for just a minute, because California has proposed draft regulations on cybersecurity audits, and the draft would impose sort of requirements for certain covered businesses to conduct an annual audit every year, and to sort of identify weaknesses and status of previous weaknesses and make improvements. And presumably these are not going to be privileged audits, and so they'll become part of the company's business records and possibly something that you will want to access when you're doing investigations. Can you I know that the rules are sort of in draft, there's probably only so much you can talk about, but can you sort of walk us through what these rules are and how they sort of play into DOJ's sort of cybersecurity enforcement priorities?
Sure. So there's DOJ, which is Department of Justice. That's where I work. That is the chief law enforcement agency for the state of California. We enforce all consumer protection laws, including privacy laws. There is a new state agency called the California Privacy Protection Agency. They are led by a 5-member board. They have parallel administrative enforcement authority over the California Consumer Privacy Act, the CCPA, which was the first in-nation comprehensive consumer privacy framework. As part of an amendment to that law that was done by ballot initiative in 2020, there was a requirement that this agency promulgate regulations related to a cyber audit, a cybersecurity audit. That has just been released in draft form, but I really want to underscore that it is in draft form. There is multiple opportunities to engage and provide public comment to the agency on whether or not these rules make sense. This is a little hot. I'm just keep going. Sorry. So the state agency is actually going on a roadshow around the state of California to solicit public comment and to solicit feedback from those who might be interested. They have 3 dates in which they're going to be both in person and online in Los Angeles, Fresno, and Sacramento starting next week. And what's happening is that you can have the opportunity to go and speak to the agency about their proposed regulations. And then once they solicit that type of public feedback, they're going to go back to their board, propose to start formal rulemaking, at which there will be another opportunity for formal comments to be submitted, in which the public can provide commentary on the draft proposed rules. So the long and short of this is that the draft rules that were proposed are significant. It's the first time there's this type of audit requirement on companies. But there is a lot of opportunity for public engagement, and there should be, because the rulemaking process really is one in which California requires public engagement. So I just want to put that out there. So what's particularly interesting about this is that, as you said, Beth, it applies to a business which has either 50% revenue from selling personal information, or has made over $28 million in annual gross revenue and processed personal information of 250,000 or more consumers, or the sensitive personal information of 50,000 or more. And so if that's the type of business that you're engaged in, these rules would apply to you. The requirement is that you need to select an auditor, conduct the assessment, loop in senior decision makers, and submit a certification that you've done the audit to the agency. So I think, again, this is proposed. The requirement is that you're supposed to submit a certification, not the entire audit that you've conducted. The auditor could be internal, but it seems as if, in most cases, it might be a third party that would be conducting this audit. The auditor would have to report to the business's board, governing body, or highest ranking executive who didn't have direct responsibility for the cybersecurity program. So there's this idea of maintaining some independence for the auditor to be able to engage with senior members of the business. The rules go into greater detail about what the audit includes. You make an assessment about how the business protects personal information through its cybersecurity program, its policies and procedures, the gaps and the weaknesses identified, as well as mitigation. And right now, there's in order to complete this cyber audit, there's 24 months. So there is a long runway period from when the rules become final to when the first audit or the first assessment would be due. So I think for purposes of enforcement, this is particularly interesting, right? Right now, the Attorney General, there's a requirement that when there's a data breach, for example, that applies to personal information that's very narrowly defined, that there needs to be a submission of that notification to the AG if it's in excess of 500 or more Californians. We review every single data breach notice that comes through the portal. So we're used to looking at all types of notices relating to security events. We also have had a range of enforcement actions as it relates to a breach of security. Both, sometimes I affectionately refer to it as my analog cases, which involved, for example, I had a case where the envelope window was oversized and revealed that the recipient was taking HIV medication. So that's, we looked at data security with a very broad lens in terms of how people's information is protected or not. But for purposes of cybersecurity audits, I think we're going to have a real interest in looking at the documentation that goes into preparing this type of audit, to see if a company has a breach or, hasn't fulfilled its obligations under the law.
Great. So we're going to take questions in just a few minutes while we're talking. So if you're interested in asking a question, feel free to make your way up to one of the mics. But Katya, while people are going to the mics, can you talk a little bit about sort of the heartburn that you anticipate in-house from these cybersecurity audits?
Yeah. So obviously having to do another detailed security audit on top of what a company may already be doing regularly adds to additional resources, expense, bandwidth. That's one. There are some differences, even though a company may already be doing regular yearly audits, things like alignment with the NIST cybersecurity framework or the ISO 27 series, which a lot of the controls tested in the proposed CCPA cyber audits cover the same security controls. There's some new and different aspects of the security program that the CCPA proposed audits are testing. Things like your vulnerability disclosure program, whether you have an inventory of personal data, software, hardware. So this may not be things that are regularly tested as part of other audits, which on the one hand can be novel. On the other hand, it's an opportunity to take a closer look at how these processes look and improve them and have them assessed externally, which can be really valuable. Another operational kind of difference is that if an internal auditor is doing the CCPA cybersecurity audit, like Stacey said, they have to report to the board of directors. And that's not necessarily how some companies may operate. There may not be a direct connection between auditors. Maybe they typically report to senior management in cybersecurity, so that can be an operational change or something that's done differently.
Okay, I see a few questions. Go ahead.
Hi. My question is there a difference between CISO and Chief Data Officer from perspective of personal liability that you spoke about?
That's a great question. And so I think when we're talking about personal liability, it was interesting when I talked to the SEC a number of times about the prosecution of the SolarWinds CISO, and what they and why it was the CISO and not the CEO or someone else. Why it was, this in the same question could be asked about the Joe Sullivan case. And in that case, the enforcement lawyers were talking about, well, we look to the individual who was best placed to have prevented what happened, or the individual who was made the decision, for example, not to disclose. And in that case, in the SolarWinds case, what I think the SEC would say is that the CISO had knowledge of the issues that were happening and had direct reports telling him what was going on, while not necessarily briefing that up higher. And so they found him to be sort of this focal point of a failure or the culmination of the fraud. And I think that you might see the same issue of a chief data officer or chief privacy officer if that person is playing a similar role, right? And so it's not about the title, it's about, and so I guess we're using CISO on this panel a little bit sort of loosely, but what they're looking for is the individual who had both the top responsibility and the ability, the knowledge and the ability to have changed what happened. And that's why you're looking at the CEO in Drizzly, because I think their security team was actually quite immature and more junior, and the CEO had more visibility and ability to have changed it, and why you're looking at why the SEC is looking at the CISO and SolarWinds. Go ahead.
Thank you. As a regulatory attorney in-house, we're seeing in California, legislation happening on automated decision-making while regulations are being created around the same topic. We see on the federal level different agencies doing different things, and I'm curious how you would all advise your clients around the uncertainty in this, and just how do we manage that uncertainty for our clients, whether it's the CISO or the business?
I think it's a great question. I'm happy for you guys to talk about it in-house, and then I can talk about it from outside counsel perspective.
Yeah, so we, as best practices, stay informed, stay on top of what is going on, both on regulation side, when regulations are still in draft proposed form, and monitor closely developments. Obviously monitor all enforcement actions in the US and globally, study the cases when they come down the pike, like the FTC enforcement cases, pay close attention to the facts, and what are the factors that the regulators deem as to be insufficient security practices and best practices. And given that there's a flux of regulation to the uncertainty you were speaking of, try to stay as up to date as you can on all developments, develop frameworks for compliance that integrate as much of the various regulations as possible, have some kind of overarching framework so when new requirements come in to the compliance team, they can incorporate new requirements rather than having multiple compliance program. That's usually the easiest way to deal with many regulations.
Yeah, I mean, I think it's a really great question, and it's one that I often am talking to my clients about, because they'll look at like GDPR or the EU AI Act, and they're so big and robust that and they think this is what I need to be focusing on. And I'm, sitting in a global firm with no shortage of like European colleagues, and I'm saying, actually, I think it's going to be harder to comply with US regulation, the EU regulation, because they wrote it all down and it's all in the same place. And in the United States, I can't tell you, like every single cabinet agency is doing its own thing, and every state is doing its own thing, and they're not necessarily compatible. The sort of two pieces that I would like really focus on is one, when draft regulations are drafted, they are drafts. And so you sort of get an idea of where it's going, but I try to tell my clients, look, let's not panic. Things will change. I think that you saw that in the SEC rules. And there's also a time between implementation or when it's going to be enacted and how long you have. I think the SEC rules were particularly heartburn because it was going to be a heavy lift and it was 90 days. And so you had to do some tea leaf reading. I think the other piece that I would say is if you have a mature cybersecurity program in place, and you're thinking through these things, which are we have policies in place, we understand our framework for governance, whether it's NIST or SIS-20, we know where our weaknesses are and where our investments are, we have a robust method of communicating up to executives for decisioning, for doing risk acceptances and for sitting it down, then you will find that a lot of these regulations are tweaks to your framework rather than something that you're scrambling to build. And so when I see a client sort of panicking around new regulations, it tends to be a symptom of a more immature program than it is about how onerous the regulations are. Everyone's swimming in the same direction. They just have a different sort of nuance in how they do it. And I think if you're looking at sort of reasonable compliance with a myriad of regulations, you will find that there's a big body to work with in that. But that takes a lot of smart lawyering and, frankly, investment in the maturity of a program. Go ahead.
Yeah, this question is for Stacey. By the way, thanks for being here. It's a great conversation. You mentioned something about companies getting into trouble with the law, not following the basic security standards. So, and my clients, I work in this industry a lot, they struggle with that a lot. They say, what does basic mean? And I was wondering, just from your perspective, Is there a benchmark you use to kind of determine, or they are out of line with some of the most fundamental things? And
Yeah.
what are those things?
Okay, so I can give you an example from an
Yeah.
enforcement action if you want me to.
Yeah.
We brought an enforcement action against a mobile app operator, Glow, and we alleged basic security failures. The Glow is a fertility tracking app, right? And there was requirements to protect the data. We found, based on an investigation, that it was when a consumer wanted to change their password, they weren't checking on the back end that the old password matched what the consumer would enter, so you could just force a password change. That seems to be pretty basic data security practices 101. In addition, you could join a partner with your app, so that the partner that you presumably are trying to start a family with or get pregnant with could follow along and have access to your account, but the app never confirmed that you gave permission or authorized that specific user, so anyone could then connect to your account. So that does not seem to be reasonable data security to protect personal information. We're talking like pretty glaring data security failures. I would say that in 2016, we used to have be able to analyze all of our data breaches, and we had made a recommendation, I think it was in 2016, about minimum data security standards, and we cited the Center for Internet Security 20 controls as a baseline for what reasonable security is. That was 2016, though. It's 2024, and I'm sure that since it's now become outdated. And so I think that reasonable data security is an evolving standard. It's supposed to be, because security is constantly changing in terms of what you have to do to protect your systems, and as well as the data that you're storing. And so it really is important to stay on top of that and consult existing frameworks, NIST frameworks. I think that those are good standards to follow along with. But there has to be communication within your organization.
I think we have time for one more question.
Oh boy, the pressure, sorry.
And then we'll stay behind afterwards.
What is the best way for an organization to stay on top of what's coming in the pipeline? So I work at a small private but global company, and we were caught flat-footed with one of our IoT devices. There's a new UK law that came out, and the passwords, you have to have unique. You have to be able to, make them, let them change it or make them change it. And now, engineering is scrambling, and they're looking for like some sort of solution or a consultant who can help them navigate what's coming down the pipeline. Is there a sort of clearinghouse where you can find out what's going on to keep your hand on the pulse, if you will?
I'll be interested in what you guys do in-house. So I will say, we're a global law firm with 2,000 attorneys. We have 2 librarians, we call them librarians, who are like full attorneys who do nothing except for scour the world for new regulations on data. And they don't do any client services work. They're just like our eyes and ears, sort of gathering this stuff and putting it together for us. And we use probably no fewer than 4 different tools to try to collect global regulatory requirements. One for Europe and UK, one for the United States, one for Asia, and one for sort of like the BRICS. And so it is not easy, and I have not found sort of a cost of, I would not say, for us, we're doing this for our 3,000 clients, and we provide that information as sort of a service. But it is a massive investment, and the investment that we have had to make as a law firm that focuses on data has been, I would say, exponential over the past 5 years in a way that I had not seen it before.
I would just encourage you, a lot of law firms, and even some like the policy centers and things in cybersecurity, they have newsletters that are specific to cybersecurity and privacy, and they will talk about legislation that's being drafted or up for comment or things like that. And I found that to be a low cost way to kind of have a sense of things, that and just like keeping in contact with our different global counsel that are out in the UK or out in these different areas, and trying to work with them to have them flag to like the corporate lawyers what's happening in their regions.
I would agree with all of that. Work closely with your counsel if you have one, outside counsel. They will be a good source to update you and provide you with news and developments. And like JJ said, there are a number of global law firms that you can subscribe to updates and alerts. And even when you're subscribing, they can ask you what's your area of interest. So you can receive all updates on that topic that are pertinent to your company. Subscribe to other industry alerts and updates. AIPP also has some good ones if you're a member, or maybe even if you're not a member, you can still find very good content. But basically, yeah, subscribe to relevant industry news.
Okay. Thank you.
So I think we're at time. So I'll just sort of wrap up by saying, look, we didn't scrape the surface. We left a lot of things on the cutting room floor, including DHS's new rules, including the National Cybersecurity Strategy, to what extent that's going to, be implemented. So, obviously there's a lot coming. I think that we are becoming a regulated, highly regulated industry, and it's something that we can't ignore. Thank you so much.
Thank you.